How can someone possibly sue for defamation when they are, at the very least, in part responsible for the damages to their own reputation as a result of their own conduct? Someone is going to be asking the Osundairo brothers that very question.
It's vlog time.
Viva Frei, Montreal litigator turned YouTuber. I'm going to be a little stiff this episode because I pulled a muscle in my back yesterday at a water park doing a backflip off one of those rope swing thingies.
Let go.
Alright, that obviously wasn't me. Mine was a perfect backflip dismount, but I seem to have pulled something of a muscle in my back. There's a dog here, hold on 1 second. Oh yeah, here he is, Barney the vlog dog. Alright, I'm shooting on the roof today because I can't get any quiet time in the house because it's summertime, kids are out of school, the house is filled with noise of love. Yes, Barney, thank you. Alright, we are tackling the Osundairo defamation lawsuit against Jussie Smollett's attorneys. This vlog just keeps on going. Alright, for those of you who have been living under a rock, in a cave with no electricity or neighbors to tell you what's going on in the world. Jussie Smollett claimed to have been the victim of a racist and homophobic hate crime perpetrated in Chicago. The story broke and went viral everywhere. The Chicago Police Department very quickly grew suspect and attention turned to two brothers named the Osundairo brothers. It turns out that the Osundairo brothers perpetrated the attack on Jussie Smollett at his request paid by him. Jussie Smollett was indicted on 16 felony charges, including providing a false report to police, and just like that, the state attorney dropped all charges against Jussie Smollett and he walked free. After the charges were dropped against Jussie Smollett, instead of just going quietly into the night, he continued to proclaim his innocence and continued to assert that he was the victim of a racist and homophobic hate crime perpetrated by the Osundairo brothers. Smollett's attorneys, Glandian and Geragos, came out on numerous outlets to proclaim that the Osundairo brothers in fact perpetrated a racist and homophobic hate crime against Jussie Smollett. And what do the Osundairo brothers do? They sue Jussie Smollett's attorneys for defamation. Now, I've already done a video on this subject as to whether or not someone can sue an attorney for defamation for statements made for and on behalf of their client. I'll link it right here. But now I'm actually going to walk you through the lawsuit filed by the Osundairo brothers because it is tremendously interesting and contains allegations which are themselves tremendously interesting. But the most interesting question in all of this is going to be whether or not the Osundairo brothers can actually sue for damages for defamation when one might argue that the damages to their reputations resulted from their own very conduct. Alright, so first off, something totally cool about this whole YouTube channel is the people I get to meet in the virtual world. A lawyer from South Dakota named Stuart Hughes reached out to me and said, if you ever need any help getting proceedings or accessing the court file, drop me an email and I can see what I can find. So in doing research for the Osundairo brothers lawsuit, I emailed Stuart and asked him if he was able to see any developments in the court file of the Osundairo defamation lawsuit. The Osundairo brothers filed their lawsuit in April 2019, and I wanted to make sure that there had been nothing material developing in the file prior to making this video. And Stuart in fact found something relatively interesting, at least from a legal perspective, in the court record. It seems that the Osundairo brothers counsel filed what is referred to as an attorney's lien against any sums to be recovered in the actual court file. Attorney's lien. Now comes Gregory E. Coulis and Associates Limited, and in support of their attorney lien states as follows. Gregory E. Coulis and Associates Limited is currently legal counsel for the plaintiffs, Olabinju Osundairo and Abimbola Osundairo. While representing the plaintiffs, Gregory E. Coulis and Associates Limited is incurring legal expenses and costs. This is a notice of our attorney's lien in conjunction with our attorney-client contingency agreement and statutory fee provision under 42 U.S.C. 1988. Respectfully submitted, Gregory E. Coulis. And this is interesting. I have never seen this in my practice, although I could make out what it was. A lien is sort of like a real right, a hypothek that you register against something, assets, revenue, income, etc. Meaning that if the Osundairo brothers actually collect anything in the context of this lawsuit, their attorneys have filed a lien, have protected themselves, and registered a right against a certain portion of whatever sums go to the brothers to pay for the legal fees they've incurred in conjunction with their contingency agreement with the Osundairo brothers, because obviously the attorneys took this file on a part contingency, maybe part hourly rate, whatever, but they are working on contingency. And in order to ensure that they get paid, if the Osundairo brothers get paid, they've registered and filed a lien against any sums the Osundairo brothers are to collect in the context of this lawsuit. Now, apparently judges limit the amounts that attorneys can actually collect based on an attorney's lien for sums to be recovered by the plaintiff in lawsuits, presumably to prevent massive windfalls in contingency agreements a la Joe Jamail's $300 million contingency payment in the Pennzoil lawsuit from years back. And I don't know if when attorneys file these types of liens, it's generally a sign that their relationship with their client is heading south, in that they no longer trust their clients to actually pay them in the event that their clients get paid, but whatever. The Osundairo brothers attorneys, if they are still currently the attorneys of record, have filed an attorney's lien against any sums the Osundairo brothers collect in this lawsuit. But let's get to the actual lawsuit now. Olabinju Osundairo and Abimbola Osundairo individual plaintiffs versus Mark Geragos, Tina Glandian, and Geragos and Geragos law firm defendants. Jury demand. We have a bunch of introductory paragraphs, but paragraph 6 relates to the jurisdiction and venue. The court has personal jurisdiction over defendants since they have availed themselves of Illinois law in numerous ways. First, they conducted business in the state of Illinois. Defendants transacted as criminal counsel for Chicago actor Jussie Smollett, hereinafter Mr. Smollett, defending his Illinois criminal case and often acting as de facto public relations representative while in Illinois. Second, defendants also committed torts within the state of Illinois by making public defamatory statements against plaintiffs, which were published broadly in Illinois by major news outlets such as the Chicago Sun-Times, the Chicago Tribune, and WGN Radio. And that's an important allegation because, like I've said in other videos on the subject, when it comes to defamation and jurisdiction, one can justify the proper jurisdiction based on where the defamation occurred. And because here we clearly have the Osundairo brothers who want to keep the lawsuit in Illinois and not necessarily in California where the attorneys and their law firm resides, we have an allegation to the effect that the defamation in question occurred in the state of Illinois, such that the courts of Illinois have jurisdiction and that it is in fact the proper venue. Moreover, these tortious statements involve a hoax conducted in Illinois and orchestrated by Mr. Smollett. Finally, and importantly, these statements also impacted the reputations of plaintiffs who are employed and live in Illinois. Pursuant to the Illinois long-arm statute and federal law, defendants have maintained minimum sufficient contacts with the state of Illinois to establish personal jurisdiction. And there you have it, an allegation of facts so that plaintiffs can establish the law that they require in order to establish jurisdiction in the venue that they want. And then we have some more introductory paragraphs setting out the facts that we all know very well by now. And one allegation that we'll get back to, but I want to read, is paragraph 15. In short, Mr. Smollett used his clout as a wealthy actor to influence plaintiffs who were in a subordinate relationship to him and were aspiring to, quote, make it in Hollywood. And we're going to get back to that theme, which is going to be fleshed out in the context of this lawsuit, because like I said in the intro of this video, you have the Osundairo brothers who themselves carried out certain acts which one can reasonably say negatively impacted their reputations, that being having participated in staging a fake hate crime against Jussie Smollett. But then on the other hand, you have the Osundairo brothers who, while guilty of certain things, may not in fact be guilty of the things that Glandian and Geragos were alleging that they were guilty of. And the question ultimately at trial is going to be what damages were done to their reputations and why. Was the damage to their reputation done because of things they did or because of the things Geragos and Glandian said they did that they in fact or alleged they did not do? But we're getting ahead of ourselves. So bear in mind that after all the charges were brought against Jussie Smollett and they were all suddenly dropped by the state attorney, Jussie Smollett nonetheless came out and personally and through his counsel publicly asserted that he was in fact innocent and the victim of a racist and homophobic hate crime. And who were they alleging were the perpetrators of this racist and homophobic hate crime? The Osundairo brothers. Paragraph 26. Ms. Glandian insisted Mr. Smollett was innocent of making a false police report and falsely added that plaintiffs criminally attacked Mr. Smollett. Paragraph 30. Ms. Glandian's statements indicating plaintiffs actually criminally battered Mr. Smollett without his consent are patently false and defamatory, as Mr. Smollett originated, planned, and orchestrated the attack. And here we have sort of a very interesting distinction in law, whereas if this was all part of an orchestrated plan, the battery was done with Jussie Smollett's consent at his direction, versus actual criminal battery, which would have been done without Jussie Smollett's consent, which would be an actual crime. And so when Glandian is coming out saying that Jussie Smollett is innocent and that he was in fact criminally battered, it is implying and directly stating that the Osundairo brothers battered and assaulted Jussie Smollett without his consent, which is accusing them of an actual crime and further accusing them of having lied under oath to the grand jury. And some might say that there is in fact a material difference between being silly enough to have participated in this plan orchestrated by Jussie Smollett versus actually committing criminal assault and battery against Jussie Smollett by perpetrating an actual racist and homophobic hate crime against Jussie Smollett. Two very big and different things. And so the distinction, although subtle, and I can understand how some people are going to say it's immaterial, in law is still relevant because the accusations of having participated in a stupid plan is much different than allegations and accusations of having perpetrated a racist and homophobic hate crime against a very famous actor. Paragraph 33. Ms. Glandian's statements that plaintiffs donned whiteface on the day of Mr. Smollett's alleged attack are patently false and defamatory, as neither wore whiteface or pretended in any way to be Caucasian. And there's a part of me that has trouble reading this with a straight face because they're basically saying, yes, we did something tremendously stupid, but we didn't do it the way you say we did it, we just did it another way, that being with the consent of Jussie Smollett. But there are differences in law and there are different consequences in law, and we'll flesh them out a little more fully as we get through this lawsuit. Let's keep going. Ms. Glandian's statements were made after the close of Jussie Smollett's criminal case, did not serve any legal function, and was not a requirement of her job as a defense attorney. Instead, these statements were unnecessarily made on national media to advance Mr. Smollett and Ms. Glandian's reputation and fame at high cost to plaintiffs. And this is an important distinction that we touched on in the previous video as to whether or not one can sue attorneys for defamation for statements made on behalf of their clients. Generally speaking, lawyers benefit from what is referred to as absolute immunity immunity when making representations for and on behalf of their clients. And this absolute immunity can be reduced to relative immunity depending on the circumstances, whether or not a lawsuit is reasonably anticipated, and an attorney can lose any such immunity when they're making these statements for absolutely no purpose required of their representation of a client. And here we have the Osundairo brothers saying that these statements made by Glandian at this point served no function of a defense of her client because there were no criminal charges being brought against her client. The allegation is that these were made after the close of the criminal file, purely in an attempt to save Mr. Smollett's reputation and to further Ms. Glandian's reputation as a high-profile defense attorney, and as such can constitute defamation against the plaintiffs. Paragraph 42. As a result of Ms. Glandian's false and defamatory statements, plaintiffs suffered and will continue to suffer damage, including economic damages, damages to their reputations, and/or damage to current and prospective business relations. And when I first read that allegation, I found it to be somewhat incredulous, as though the Osundairo brothers are going to suffer damages as a result of Ms. Glandian's statements and not as a result of their own conduct. But the rest of the lawsuit does a relatively decent job in alleging why the statements made by Glandian are going to have a particularly nefarious effect on the Osundairo brothers' reputations as compared to what the Osundairo brothers did themselves. So let's get to that. Paragraph 46. Ms. Glandian falsely stated that plaintiffs are involved in, quote, illegal, end quote, Nigerian steroid trafficking, and that these steroids help clients lose weight. Ms. Glandian added, scoffing, that plaintiffs, quote, platform is all about being steroid-free. Their whole thing is, you know, all natural bodybuilding. It's ridiculous. Plaintiffs do not use or distribute illegal Nigerian steroids. And here we are seeing the different types of damages to one's reputation resulting from different causes. Yes, the Osundairo brothers participated in this ridiculous hoax, which is obviously going to cause damages to the reputation to some extent. But to go from that to have an attorney stating on national media that the brothers are participating in the illegal trafficking of Nigerian steroids, one can easily see a difference between the types of damages that they can suffer as a result of their own actions versus as a result of Ms. Glandian's statements. And I've said this in previous videos, accusing someone of having committed an actual crime, accusing someone publicly of criminal conduct, oftentimes will qualify as defamation. It's a very serious thing to publicly accuse someone of criminal conduct. But the differences in the damages to the reputations that the Osundairo brothers can suffer as a result of their own conduct versus as a result of Ms. Glandian's statements don't end there.
Let's get to it.
Section 3. Statements falsely accusing plaintiff of engaging in fornication with Mr. Smollett. On or around April 6, 2019, defendant Tina Glandian further discussed plaintiff Ambimbola Osundairo, hereinafter Bola Osundairo, on the podcast Reasonable Doubt. Ms. Glandian inferred that Bola Osundairo and Mr. Smollett engaged, at least briefly, in homosexual acts together. These statements were made to the third-party press and public. Paragraph 60. Bola Osundairo is heterosexual and was dating a woman at the time. Paragraph 61. Bola Osundairo has never engaged in any sexual acts with Mr. Smollett, thus Ms. Glandian's statements are patently false. And at paragraph 62, we can really appreciate the nefarious consequences of Ms. Glandian's public statements. Bola Osundairo is also Nigerian-American, has family in Nigeria, and enjoys visits to Nigeria. Same-sex sexual activity is illegal in Nigeria, which can result in 14 years imprisonment. If the accused is married, the punishment is death by stoning. Now, we know that under American law, truthfulness is an absolute defense to allegations of defamation. If the statement is true, then you can't sue for defamation. That being said, you do have something called public disclosure of a private fact, which is sanctionable in the US. So from a legal perspective, Tina Glandian's statements can be problematic one way or the other. They are either defamatory because they are false and defame an individual, causing them obvious problems, especially if they decide to go back to a country where they can potentially be imprisoned for having done what Tina Glandian publicly stated they did. Or if it happens to be true, what you might have here is a public disclosure of a private fact that will necessarily cause harm to the individual whose private fact is being publicly disclosed. The allegations are not only that these statements are defamatory, but that they actually place one of the plaintiffs in physical risk if he goes back to Nigeria and they decide to imprison him for what is illegal in Nigeria but totally legal in the United States. And the question that I'm asking myself while reading all of these things that Tina Glandian is alleged to have said is, what function, what purpose did these statements serve? Why was she saying these things? What case, what file was it furthering? What defense was it furthering? What was the ultimate goal of alleging that the Osundairo brothers are engaging in illegal steroid trafficking or engaging in homosexual activity? What purpose do all of these allegations serve, if only to defame the plaintiffs? And at paragraph 66, plaintiff's attorneys allege as much. Ms. Glandian's statements were made after the close of Mr. Smollett's criminal case, did not serve any legal function, and were not a requirement of her job as a defense attorney. And then later on in the lawsuit, we see a header called Common Law False Light. And the question I was asking myself is, what is the difference between common law false light and defamation? As relates to defamation, we know what the criteria are, but let's just repeat them for the sake of clarity. Defamation requires the communication of a statement about the plaintiff to another party. The statement has to be injurious to the plaintiff's reputation. The statement has to be false false in order for it to constitute defamation. And if the plaintiff is a public figure, as we know, the threshold is a little higher, and the false statement has to have been made either intentionally or with reckless disregard for the plaintiff's rights. False light, however, is slightly different in that the statement doesn't have to necessarily be entirely false, but rather only portray the plaintiff in a false light. And the criteria for establishing false light involve publishing a statement about the plaintiff to another party. That statement or information must portray the plaintiff in a false or misleading light. The statement contains information that is highly offensive or very embarrassing to the plaintiff in question, and the defendant published the statement either intentionally or with reckless disregard as relates to its offensiveness or embarrassing nature. Some say that false light claims are easier to bring than defamation, but some states don't recognize false light claims and they can't be brought in every jurisdiction. Some states have ruled that false light claims have to be rewritten as defamation lawsuits, and I presume, based on the jurisdiction and based on the fact that they are making a false light claim in this lawsuit, that Illinois allows for false light claims in addition to defamation lawsuits, which might explain why the plaintiffs want to choose Illinois as the proper jurisdiction so that they can make not only a defamation lawsuit, but also a lawsuit in false light. And I have to take the kids to camp, don't I? No, I'll do it, I promise. Okay, I'll be back. Alright, one more thing about the difference between false light claims and defamation claims. False light claims don't necessarily have to be false in and of themselves, but the implication has to be false. And so the analogy that I can think of as relates to this lawsuit, the allegation that one of the Osundairo brothers engaged in homosexual acts with Jussie Smollett would be a defamatory statement if in fact false. However, hypothetically, an allegation to the effect that the Osundairo brother went on a weekend trip with Jussie Smollett might in and of itself not be false, unless it is used to suggest, imply, or otherwise support the allegation that one of the Osundairo brothers engaged in homosexual activity with Jussie Smollett, in which case it would fit into the false light, but not necessarily the defamation, because although true, the implication is false. But how does Geragos fit into this lawsuit? Because up until now, all we have heard are the alleged defamatory statements uttered by Glandian. Well, the allegations implicating Geragos and his law firm start at paragraph 82, which reads as follows. On the same podcast in which Ms. Glandian made tortious and defamatory statements about plaintiffs, defendant Mark Geragos, hereinafter Mr. Geragos, also appeared and occasionally made comments. Mr. Geragos falsely stated that he could not think of anyone else who committed the hate crime against his client, Mr. Smollett, besides plaintiffs. Mr. Geragos repeatedly indicated that plaintiffs conspired to criminally attack Mr. Smollett, and by doing so implied plaintiffs committed perjury before the February 20th, 2019 grand jury and conspired to make false statements to Chicago police. Moreover, the above defamatory statements in counts 1 and 2 made by Ms. Glandian were made in concert with and approved by Mr. Geragos to promote his law firm and his reputation. Mr. Geragos' statements were made after the close of Mr. Smollett's criminal case, did not serve any legal function, and were not a requirement of his job as a defense attorney. And this is sort of the leitmotif of the entire lawsuit, to reiterate that what Geragos and Glandian did, what they said, the statements they made, were not part of an active file in defense of their client. They were made after the close of the criminal file, not in the context of any civil proceedings between the parties, and therefore served no function of representing a client, such that they should no longer benefit from the immunity that would otherwise be granted to an attorney representing his or her client. And at paragraph 91 and following, we have the allegations incorporated by reference mutatis mutandis to the false light claim. Additionally, Ms. Glandian's above tortious statements were made in consort and coordination with Mr. Geragos in an attempt to promote his law firm and reputation. Mr. Geragos' tortious statements explicitly identified plaintiffs in making these untrue statements. Even when he referred to them by pronouns, they are all still easily identifiable. In furtherance of the leitmotif running through this lawsuit, paragraph 96, Mr. Geragos' statements were made after the close of Mr. Smollett's criminal case, did not serve any legal function, and were not a requirement of his job as a defense attorney. And at paragraph 98 and following, we have the concept referred to as Respondeat Superior. Now, I know what it meant in the context, but I never actually heard of the concept before and had to look it up. Respondeat Superior is the legal doctrine that a party is responsible for the acts of their agents. In the United States, it's the doctrine that an employer is sometimes responsible for the acts carried out by their employees in the context of their employment. Respondeat Superior. Let's read the allegations. Paragraph 99. At all relevant times, the defendants Tina Glandian and Mark Geragos were acting within their scope of employment as employee and partner, respectively, of Geragos and Geragos Law Firm. Geragos and Geragos Law Firm is responsible for the actions of their agents, wherefore the plaintiffs Olabinjo Osundairo and Abimbola Osundairo pray for judgment against defendants Geragos and Geragos for the appropriate compensatory damages, punitive damages, and costs. Jury demand. And there you have it, a breakdown of the Osundairo's defamation lawsuit against Jussie Smollett's attorneys. Make your predictions now as to how you think this is going to end. I can't even venture a prediction on this one. I don't know which way this is going to go. But regardless, if you like my videos and you like this content, be sure to like, share, subscribe, hit the notification bell, share my channel with anyone who will listen, and now you know your vlog. Peace out. Boom!